Hello, fellow We the People. I'd like to share with you today the Citizens Rulebook. It's real interesting. I suggest that every American get a copy, read it, study it, and live by it, second only to the Bible. The Bible is the only book that I would put in front of this Citizens Rulebook. Lincoln said, "Study the Constitution. Let it be preached from the pulpit, proclaimed in legislatures, and enforced in courts of justice. Rights come from God, not the state. You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by human laws. Rights derived from the great legislator of the universe, John Adams, the second president of the United States. That this nation, under God, shall have a new birth of freedom, Abraham Lincoln. Jury duty. The purpose of this book is to revive, as Jefferson put it, the ancient principles. It is not designed to promote lawlessness or a return to the jungle. The ancient principles refer to the Ten Commandments and the common law. The common law is, in simple terms, just plain common sense, and it has roots in the Ten Commandments. In 1776, we came out of bondage with faith, understanding, and courage. Even against great odds and with much bloodshed, we battled our way to achieve liberty. Liberty is that delicate area between the force of government and free will of man. Liberty brings freedom of choice to work, to trade, to go and live wherever one wishes. It leads to abundance. Abundance, if made an end in itself, will result in complacency, which leads to apathy. Apathy is a let-George-do-it philosophy. This always brings dependency. For a period of time, dependents are often not aware that they are dependent. They delude themselves by thinking that they are still free. We never had it so good. We can still vote, can't we? Eventually, abundance diminishes and dependency becomes known by its true nature, bondage. These are a few ways out of bondage. Bloodshed and war often result. But our founding fathers learned of a better way, realizing that the Creator is always above and greater than that which He creates. They established a three-vote system by which an informed citizenry can control those acting in the name of government. To be a good master, you must always remember the true pecking order or chain of command in this nation. 1. God created man. 2. Man created the Constitution. 3. The Constitution created government. 4. The government created corporations. The base of power was to remain in we the people, but unfortunately it was lost to those leaders acting in the name of government, such as politicians, bureaucrats, judges, and lawyers. As a result, America began to function like a democracy instead of a republic. Democracy is dangerous because it is a one-vote system as opposed to a republic, which is a three-vote system. The three votes to check tyranny, not just one vote. American citizens have not been informed of their other two votes. Our first vote is at the polls on election day when we pick those who are to represent us in the seats of government. But what can be done if those elected officials just don't perform as promised or expected? Well, the second two votes are the most effective means by which the common people of any nation on earth have ever had in controlling those appointed to serve them in government. The second vote comes when you serve on a grand jury. Before anyone can be brought to trial for a capital or infamous crime by those acting in the name of government, permission must be obtained from people serving on the grand jury. The Minneapolis Star and Tribune in March 27, 1987 edition noted the purpose of the grand jury in this way. A grand jury's purpose is to protect the public from an overzealous prosecutor. The third is the most powerful vote. This is when you are acting as a jury member during a courtroom trial. At this point, the buck stops with you. It is in this setting that each juror has more power than the president, all of Congress, and all of the judges combined. Congress can legislate law. The president or some other bureaucrat can make or issue a regulation, and judges may instruct or make decision, but no juror can ever be punished for voting not guilty. Any juror can, with impunity, choose to disregard the instruction of any judge or attorney in rendering his vote. If only one juror should vote not guilty for any reason, there is no conviction and no punishment at the end of the trial. Thus, those acting in the name of government must come before a common man to get permission to enforce a law. You are above the law. As a juror in a trial setting, when it comes to your individual vote of innocent or guilty, you are truly answerable only to God Almighty. The First Amendment to the Constitution was born out of this great concept. However, judges of today refuse to inform the jurors of their rights. The Minneapolis Star and Tribune, in a newspaper article appearing in its November 30th, 1984 edition entitled "What Judges Don't Tell the Jury," stated, "At the time of the adoption of the Constitution, the juror's role as a defense against political oppression was unquestionable in American jurisprudence. This nation survived until the 1850s, when prosecutions under the Fugitive Slave Act were largely unsuccessful because jurors refused to convict. Then judges began to erode the institution of free juries, leading to the absurd compromise that it is the current state of the law. While our courts uniformly state juries have the power to return a verdict of not guilty, whatever the facts, they routinely tell the jurors the opposite. Further, the courts will not allow the defendants or their counsel to inform the jurors of their true power. A lawyer who made Hamilton's argument would face professional discipline and charges of contempt of court. By what logic should juries have the power to acquit a defendant but no right to know about that power? The court decisions that have suppressed the notion of jury nullification cannot resolve this paradox. More than logic has suffered. As originally conceived, juries were to be a kind of a safety valve, a way to soften the bureaucratic rigidity of the judicial system by introducing the common sense of the community. If they were to function ineffectively as the consensus of the community, jurors must be told that they have the power and the right to say no to the prosecution in order to achieve the greater good. To cut jurors off from this information is to undermine one of our nation's most important institutions. Perhaps the community should educate itself. The citizens called for jury duty could teach the judges a needed lesson in civics. This book is designed to bring your attention to one important way our nation's founders provided to ensure that you, not the growing army of politicians, judges, lawyers, and bureaucrats, rule this nation. It will focus on the true power you possess as a juror, how you got it, why you have it, and remind you of the basis on which you must decide not only the facts placed in evidence, but also the validity or applicability of every law, rule, regulation, ordinance, or instruction given by any man seated as a judge or attorney when you serve as a juror. One juror can stop tyranny with a not guilty vote. He can nullify a bad law in any case by hanging the jury. I am only one, but I am one. I cannot do everything, but I can do something. What I can do, I should do, and with the help of God, I will do. Everett Hale. The only power the judge has over the jury is their ignorance. We the people must relearn a desperately needed lesson in civics. The truth of this question has been answered by many testimonies and historical events, considering the following. Jury rights. The jury has a right to judge both the law as well as the fact in controversy. John Jay, First Chief Justice, U.S. Supreme Court, 1789. The jury has the right to determine both the law and the facts. Samuel Claus, U.S. Supreme Court Justice, 1796, signer of the unanimous declaration. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court Justice, 1902. The law itself is on trial quite as much as the cause which is to be decided. Harlan F. Stone, Chief Justice, U.S. Supreme Court, 1941. The pages of history shine on the instances of the jury's exercise of its prerogative to disregard instructions of the judge. U.S. v. Daughtry, 473 F. 2nd. The law of the land. The general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. Any statute, to be valid, must be in agreement. It is impossible for a law which violates the Constitution to be valid. It is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void of law. Marbury v. Madison. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona. An unconstitutional act is not law. It confers no right, it imposes no duty, it affords no protection, it creates no office, it is in legal contemplation, as inoperative as though it had never been passed. Norton v. Shelby County. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely from the date the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. 16th American Jurisprudence 2D, section 177. The summary of the Ten Commandments. The Ten Commandments represents God's government over man. God commands us for our own good to give up wrongs and not rights. His system always results in liberty and freedom. The Constitution and the Bill of Rights are built on this foundation, which provides for punitive justice. It is not until one damages another person or property that he can be punished. The Marxist system leads us to bondage, and God's system leads us to liberty. Read carefully. There shall be no other God before me. Thou shalt not make images unto me. Thou shalt not take thy name of the Lord in vain. Remember the Sabbath day. Honor thy mother and thy father. Thou shalt not kill. Thou shalt not commit adultery. Thou shalt not steal. Thou shalt not bear false witness. And thou shalt not covet. Directly above the Chief Justice chair is a tablet signifying the Ten Commandments. When the Speaker of the House in the U.S. Congress looks up, his eyes look into the face of Moses. The Bible is the book upon which this republic rests. Andrew Jackson, 7th President of the United States. The moral principles and precepts contained in the Scriptures ought to form the basis of all our civil constitutions and laws. All the miseries and evils which men suffer from vice, crime, ambition, injustice, oppression, slavery, war, proceed from their despising or neglecting the precepts contained in the Bible. Noah Webster. A summary of the Communist Manifesto. The Communist Manifesto represents a misguided philosophy which teaches the citizens to give up their rights for the sake of the common good, but it always ends in a police state. This is called preventive justice. Control is the key concept. Read carefully. Abolition of private property. Heavily progressive income tax. Abolition of all rights of inheritance. Confiscation of property of all immigrants and rebels. Central banks. Government control of all communications and transportation. Government ownership of all factories and agriculture. Government control of labor. Corporate farms and regional planning. Government control of education. Give up rights for the common good. Where the people fear the government, you have tyranny. Where the government fears the people, you have liberty. Politicians, bureaucrats, and especially judges would have you believe that too much freedom will result in chaos. Therefore, we should gladly give up some of our rights for the good of the community. In other words, people acting in the name of government say we need more laws and more jurors to enforce these laws. even if we have to give up some rights in the process. They believe the more laws we have, the more control, thus a better society. This theory may sound good on paper, and apparently many of our leaders think this way, as evident by the thousands of new laws that are added to the books each year in this country. But no matter how cleverly this Marxist argument is made, the hard fact is that whenever you give up a right, you lose a free choice. This adds another control. The control's real name is bondage. The logical conclusion would be, if giving up some rights produces a better society, then by giving up all rights we could produce a perfect society. We could chain everybody to a tree for lack of trust. This may prevent a crime, but it would destroy privacy, which is the heartbeat of freedom. It would also destroy trust, which is the foundation of dignity. Rather than giving up rights, we should be giving up wrongs. The opposite of control is not chaos. More laws do not make less criminals. We must give up wrongs, not rights, for a better society. William Penn of the British House of Commons once proclaimed, "Necessity is the plea for every infringement of human liberty. It is the argument of tyrants. It is the creed of slaves." Inalienable or natural rights. Natural rights are those rights such as life from conception, liberty, and the pursuit of happiness. An example, freedom of religion, speech, learning, travel, self-defense, etc. Hence, laws and statutes which violate natural rights, though they have the color of law, are not law but impostors. The U.S. Constitution was written to protect these natural rights from being tampered with by the legislators. Further, our forefathers wisely knew that the government legislators, unless it was clearly understood that the people had the right to compel the government to keep within the constitutional limits. In a jury trial, the real judges are the jurors. Surprisingly, judges are actually just referees bound by the Constitution. Lysander Spooner wrote as follows, "Government is established for the protection of the weak against the strong. This is the principal, if not the sole motive, for the establishment of all legitimate government. It is only the weaker party that loses their liberty. When a government becomes oppressive, the stronger party in all governments are free by virtue of their superior strength. They never oppress themselves. Legislation is the work of the stronger party, and if, in addition to the sole power of legislation, they have the sole power to determine what legislation shall be enforced, they have all the power in their hands, and the weaker party are subjects of an absolute government. Unless the weaker party have a veto, they have no power whatever in the government, and no liberties. The trial by jury is the only institution that gives the weaker party any veto upon the powers of the stronger. Consequently, it is the only institution that gives them any effective voice in government or any guarantee against oppression." Jury tampering. A jury's rights, powers, and duties. The charge to the jury in the first jury trial before the Supreme Court of the U.S. illustrates the true power of the jury. In February term of 1794, the Supreme Court conducted a jury trial and said, "It is presumed that the juries are the best judges of fact, and it is on the other hand presumed that the courts are the best judges of law. Both objects are within your power of decision. You have the right to take upon yourselves to judge of both and to determine the law as well as the facts in controversy. The jury has an unreviewable and unreversible power to acquit in disregard of the instruction on the law given by the trial judge. Hence, jury disregard of the limited and generally conviction-oriented evidence presented for its consideration, and jury disregard for what the trial judge wants them to believe is the controlling law in any particular case, sometimes referred to as jury lawlessness. It is not something to be scrupulously avoided, but rather encouraged. Witness the following quotation from the eminent legal author above mentioned. Jury lawlessness is the greatest corrective of law and its actual administration. The will of the state at large imposed on the reluctant community, the will of the majority imposed on the vigorous and determined minority, find the same obstacle in the local jury that formerly confronted kings and ministers. The right of a jury to be told of its power. Almost every jury in the land is falsely instructed by the judge when it is told it must accept the law that which is given to them by the court, and that the jury can decide only the facts on the case. This is to destroy the purpose of common law jury, and to permit the imposition of tyranny upon the people. There is nothing more terrifying than ignorance in action. Goeth. To embarrass justice by multiplicity of laws, or to hazard it by confidence in judges, are the opposite rocks on which all civil institutions have been wrecked. The letter killeth, the spirit giveth. 2 Corinthians 3:6. It is error alone which needs support of government. Truth can stand by itself. Thomas Jefferson. The jury's options are by no means limited to the choices presented in the courtroom. The jury gets its understanding as the arrangements in the legal system from more than one voice. There is the formal communication from the judge. There is the informal communication of the total culture, literature, current comment, conversation, and of course history and tradition. Laws, facts, and evidence. Without the power to decide what facts, law, and evidence are applicable, juries cannot be a protection to the accused. If a people acting in the name of government are permitted by jurors to dictate any law whatever, they can also unfairly dictate what evidence is admissible or inadmissible, and thereby prevent the whole truth from being considered. Thus, if the government can manipulate the control both the law and evidence, the issues of facts become virtually irrelevant. In reality, true justice would be denied, leaving us with trial by government and not trial by jury. How does tyranny begin? Why are there so many laws? Heroes are men of glory who are so honored because of some heroic deed. People often, out of gratitude, yield allegiance to them. Honor and allegiance are nice words for power. Power and allegiance can only be held rightfully by trust as a result of continued character. When people acting in the name of government violate ethics, they break trust in we the people. The natural result is for we the people to pull back power. The loss of power creates fear for those losing the power. During the loss of power, people acting in the name of government often seek to regain or at least hold their power. Hence, to legitimize their quest for control, laws and force are often instituted. Unchecked power is the foundation of tyranny. It is the juror's duty to use the jury's room as a vehicle to stem the tide of oppression and tyranny, to prevent bloodshed by peacefully removing the power from those who have abused it. The jury is the primary vehicle for the peaceable restoration of liberty, power, and honor to we the people. Your vote counts. Your vote of not guilty must be respected by all other members of the jury. It is the right and duty of a jury to never, never, never yield his or her sacred vote, for you are not there as a fool merely to agree with the majority, but as an officer of the court and a qualified judge in your own right, regardless of the pressures or abuse that may be heaped on you by any other member of the jury. When whom you may in good conscience disagree, you can wait the reading of the verdict, secure in your knowledge that you have voted your own conscience and convictions, and not those of someone else. You are not a rubber stamp. By what logic do we send our youth into battle tyranny on foreign soil while we refuse to do so in our courts? Did you know that many of the planks of the Communist Manifesto are now represented by the law in the U.S.? How is it possible for Americans to denounce communism yet practice it simultaneously? The jury judges the spirit, motive, and intent of both law and the accused, whereas the prosecutor only represents the letter of the law. Therein lies the liberty for those accomplishments of liberty and justice for all. If you and the numerous other jurors throughout the state and the nation begin and continue to bring in verdicts of not guilty in such cases where man-made statute is defective or oppressive, these statutes will become ineffective as though they had never been written. If ye love wealth better than liberty, the tranquility of servitude better than the amicate contest of freedom, go home from us in peace. We ask not your counsel or your arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and your posterity forget that you were our countrymen. Samuel Adams. Give me liberty or give me death. Patrick Henry. Shocked. Young Christian attorney Patrick Henry saw why a jury of the peers was so vital to freedom. It was March 1775 when he rode into a small town of Culpeper, Virginia. He was totally shocked by what he saw. There in the middle of town square was a minister tied to a whipping post, his back laid bare and his bloody, with the bones of his rib cage showing. He had been scourged mercilessly like Jesus with whips laced with metal. Patrick Henry was quoted as saying, "When they stopped beating him, I could see the bones of his rib cage. I turned to someone and asked what the man had done to deserve such a beating. Scourged for not taking a license. The reply given to him was that the man being scourged was a minister who refused to take a license. He was one of the 12 who were locked in jail because he refused to take a license. A license often becomes an arbitrary control by government that makes it a crime out of what ordinarily would not be a crime. It turns a right into a privilege. 3 days later, they scourged him to death." This was the incident that sparked Christian attorney Patrick Henry to write the infamous words which later became the rally cry of the Revolution. What is that gentleman wish? What would they have? Is life so dear, or peace so sweet, as to be purchased at the prices of chains and slavery? Forbid it, Almighty God. I know not what of course others may take, but as for me, give me liberty or give me death. Later, he made this part of his famous speech at the St. John's Episcopal Church in Richland, Virginia. Jury of Peers. Our forefathers felt that in order to have justice, it was obvious that a jury of peers must be people who actually know the defendant. How else would they be able to judge motive and intent? Peers of the defendant, like the rights of a jury, have also been severely tarnished. Originally it meant people of equals in a station or rank. Black's Law, 1910. Freeholders of a neighborhood, Bouvier's 1886. Or a companion, a fellow in association, Webster's 1828. Who has a right to sit on a jury? Patrick Henry, along with others, was deeply concerned as to who has a right to sit on a jury. Listen to our forefathers' wisdom on the subject of peers. Mr. Henry, by the Bill of Rights of England, a subject has a right to a trial by his peers. What is meant by his peers? Those who reside near him, his neighbors, and who are well acquainted with his character and situation in life. Patrick Henry Eliot, the debates in several state conventions on the adoption of the federal Constitution. Patrick Henry also knew that originally the jury of peers was designed as a protection for neighbors from outside governmental oppression. Henry states the following: "Why do we love this trial by jury? Because it prevents the hand of oppression from cutting you off. This gives me comfort that as long as I have existence, my neighbors will protect me. Mr. Holmes from Massachusetts argued strenuously that for justice to prevail, the case must be heard in the vicinity where the fact was committed by a jury of peers. A jury of peers would, from their local situation, have an opportunity to form a judgment of the character of the person charged with the crime and also to judge of credibility of the witnesses. The peoples are the masters of both Congress and courts, not to overthrow the Constitution, but to overthrow the men who wish to pervert it. Abraham Lincoln. Mr. Wilson, signer of the unanimous declaration, who also later became a Supreme Court justice, stressed the importance of the jurors, knowing personally both the defendant and the witnesses. Where jurors can be acquainted with the characters of the parties and the witnesses, where the whole case can be brought within their knowledge and their view, I know no mode of investigation equal to that by trial by jury. They hear everything that is alleged. They not only hear the words, but they see and mark the features of the countenance. They can judge of weight due upon such testimony, and moreover, it is a cheap and expeditious manner of distributing justice. There is another advantage annexed to the trial by jury. The jurors may indeed return a mistaken or ill-fated verdict, but their errors cannot be systematical. Freedom for William Penn. Those people who are not governed by God will be ruled by tyrants. William Penn. Edward Bushell. The three fellow jurors learned this lesson well. They refused to bow to the court. They believed in the absolute power of the jury. Though their 8 companions cowered to the court, the 4 jurors spent 9 weeks of torture in prison, often without food or water, soaked with urine, smeared with feces, barely able to stand, and even threatened with fines. Yet they would not give in to the judge. Edward Bushell said, "My liberty is not for sale." Though he had great wealth and commanded an international shipping enterprise, these bumbleheads, so the court thought, proved the power of the people was stronger than any power of government. They emerged total victors. The First Amendment. The year was 1617, and the case Bushell set on that of William Penn, who was on trial for violating the Convental Act. This was an elaborate act which made the Church of England the only legal church, and the act was struck down by their not guilty vote. Freedom of religion was established and became part of the English Bill of Rights, and later it became the First Amendment in the U.S. Constitution. In addition to the right to peaceful assembly was founded, freedom of speech, and also habeas corpus. The first such writ of habeas corpus ever issued by the Court of Common Pleas was used to free Edward Bushell. Later, this trial gave birth to the concept of freedom of the press. Had Bushell and his colleagues yielded to the guilty verdict sought by the judge and the prosecutor, William Penn most likely would have been executed, as he clearly broke the law. He broke the law. Then there would have been no Liberty Bell, no Independence Hall, no city of Philadelphia, and no state called Pennsylvania, for young William Penn, founder of Pennsylvania and leader of the Quakers, was on trial for his life. His alleged crime was preaching and teaching a different view of the Bible than that of the Church of England. This appears innocent today, but then one could be executed for such actions. He believed in his freedom of religion, freedom of speech, and the right to peaceful assembly. He had broken the government's law, but he had injured no one. Those 4 heroic jurors knew that only when actual injury to some person or some property takes place, there is no real crime. No law is broken when no injury can be shown. Thus, there can be no loss or termination of rights unless actual damage is proven. Many impostor laws were repealed as a result of this case. It's almost unfair. This trial made such an impact that every colony but one established the jury as the first liberty to maintain all other liberties. It was felt that the liberties of the people could never be wholly lost as long as the jury remained strong and independent, and that unjust laws and statutes could not stand when confronted by conscientious jurors. Jurors today face an avalanche of impostor laws. Jurors not only still have the power and right, but also duty to nullify bad laws by voting not guilty. At first glance, it appears that it is almost unfair, the power jurors have over the government, but necessary when considering the historical track of oppression that governments have wielded over private citizens. Thomas Jefferson's warnings. In 1789, Thomas Jefferson warned that the judiciary, if given too much power, might ruin our republic and destroy our rights. The new Constitution has secured these individual rights within the executive and legislative departments, but not in the judiciary. It should have been established trials by people themselves, that is to say, by jury. The judiciary of the United States is a subtle corps of sappers and miners constantly working underground to undermine the foundation of our confederated fabric. The federal jurisdiction, an irresponsible body for impeachment, is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the fields of jurisdiction until all shall be usurped from the states, and the government of all will be consolidated into one. When all governments, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one's government on another, and will become as venal and oppressive as the government from which we separated. The opinion which gives to the judges the right to decide what laws are constitutional and what are not only for themselves in their own spheres of action, but for the legislative and executive also in their spheres, would make the judiciary a despotic branch. Judges should be withdrawn from the bench, whose erroneous biases are leading us to disillusion. It may indeed injure them in fame and fortune, but it saves the republic. I suggest you all get this book and read it. It goes on with the Constitution and the Bill of Rights. And there's a little more comprehension when you read it yourself instead of listening to some Yahoo hillbilly like me read it to you. Anyway, I just thought I'd share this with you here. It is the Citizens Rule Book, and I suggest all Americans get it, read it, study it, and put it second only to the Bible. Thank you, people. Have a wonderful day.